Welcome to the Deep Dive. Today, we're really digging into something that trips up a lot of renters in California. How can you legally break your lease?
Yeah, it's a big one.
We've pulled together some key info stuff from Turbo Tenants 2024 guide, the SHRA portal's California Tenants Guide, and also the big guide from the California Department of Consumer Affairs.
Good sources. Comprehensive.
Our goal here is pretty simple, really. We want to give you a clear picture of when a tenant in California can actually end a lease early, without getting hit with penalties.
Let's break it down.
Okay, let's start.
So first off, maybe let's just set the baseline. How do leases normally end? The sources we looked at are clear. For a periodic tenancy, think month to month, a landlord can end it.
Right.
But they need to give proper written notice, usually 30 days, sometimes 60, maybe even 90 days in certain situations. It often depends on how long you've lived there.
Okay, so month to month, the landlord gives notice. Simple enough. But what about a fixed term lease? The standard one-year agreement. Can a landlord just boot you out halfway through?
That's where things get tighter for the landlord. During that fixed term, they can't just end it whenever they feel like it. They absolutely need just cause.
Just cause. Okay. What does it actually mean? Like, what counts?
The sources give some pretty clear examples. Number one is obvious. Not paying rent, or say seriously breaking the lease agreement. Maybe you snuck in a pet when it's strictly no pets allowed.
Right.
Also, any kind of illegal activity on the property, or if you're creating a major nuisance or, causing significant damage, waste, stuff like that.
Okay, that clarifies the landlord's side, but let's flip it. What if you, the tenant, need to get out of that fixed term lease early? This is the core question, right?
Exactly.
What are the legal ways you can end it without facing, fees or worse?
And here's where it gets, interesting. The guides we have, they don't actually list specific legal reasons, like a checklist, for a tenant to just break a fixed-term lease penalty-free.
Really? So there's no easy out clause mentioned?
Not explicitly laid out for fixed terms, no. Most of the discussion about tenants ending things focuses on those periodic tenancies, the month-to-month kind. It seems the focus is really on holding both sides to the contract they signed.
Okay, so let's talk about those periodic ones then, just to be clear. If you are month-to-month and you want to leave, what notice do you give?
Generally, you need to give written notice that matches the time between your rent payments. So pay monthly. You give 30 days written notice before you plan to move.
Got it. Now, slightly different scenario. What if your landlord gives you 60-day notice to end your month-to-month lease, but you find a new place faster? Can you leave sooner than 60 days?
Yes, you actually can. In that case, you can give your own notice that matches your rent payment period, so likely 30 days again.
Yeah.
The key thing is your move-out date just needs to be before the date the landlord set in their 60-day notice.
All right, so periodic tenancy rules seem fairly straightforward in these guides. But we still have this big question mark over fixed-term leases. Is there anything in these documents, maybe some underlying principle, that suggests situations where a tenant might have grounds to leave early without penalty?
Yes, and this leads us to a really crucial concept, the implied warranty of habitability.
Habitability, okay. Sounds important.
It absolutely is. The California Tenants Guide talks a lot about this. It's basically a fundamental part of California law. It means landlords have to keep the rental unit in a livable condition.
Livable meaning?
Meaning it meets basic health and safety standards, complies with building codes. Think essential things working properly.
So if your apartment has, a major plumbing disaster or no heat in winter or serious mold, does that warranty give you a way out of the lease?
Well, it's not quite an automatic get-out-of-lease-free card, according to these sources. They don't explicitly say if X is broken, you can break your lease penalty-free. But, and this is a big but, if there are substantial problems, serious defects affecting health and safety, and crucially, the landlord doesn't fix them within a reasonable time after you've notified them properly.
Then what?
Then the law gives tenants certain remedies, and this could potentially give you leverage or a path to leave, even if it's not called breaking the lease directly.
Okay, remedies. What kind of remedies are we talking about here?
Well, the guides mention things like repair and deduct. That's where you could potentially pay for essential repairs yourself, up to 1 month's rent, and subtract that cost from your next rent payment.
Right, I've heard of that.
But maybe more relevant to leaving early is something called abandonment.
Abandonment. That sounds pretty drastic. What's involved?
It is a serious step. Basically, if the unit becomes truly uninhabitable because of these major unaddressed problems again, after you've given the landlord proper written notice about the issues and a reasonable time to fix them,
Uh-huh.
Then the abandonment remedy might let you move out and legally stop paying rent from that point forward.
Might. So it's not guaranteed.
It's not automatic, and you have to do it right. That written notice to the landlord before you leave detailing the problems. Absolutely essential. You need that paper trail showing you flagged the issue and gave them a chance.
So you can't just pack up and leave the moment something breaks. There's a process.
Exactly. Proper notice, reasonable time for repair. If they fail, then abandonment could be on the table. But honestly, this is complex legal territory. Getting it wrong could be costly. Documentation is key, and frankly, getting some legal advice is probably smart here.
Makes sense. Now, the guides also mention subleasing and assignment. Are those ways to legally end your responsibility for the lease?
They're mentioned, yes. Subleasing is where you find someone else to rent from you. Assignment is where someone new basically takes over your entire lease.
So that sounds like a way out.
It can be a practical solution, but legally, not always a clean break. Here's the catch. Even if you sublease or assign, the original tenant, that's you, usually stays legally responsible to the landlord.
Wait, really? Even if someone else is living there and paying rent?
Yep. Unless you get something called a novation.
Novation? What's that?
It's a formal written agreement where the landlord specifically says, okay, original tenant, you're released. You have no more obligations under this lease.
Ah, so without that piece of paper, you're still technically on the hook.
Exactly. If your subtenant or the person you assign the lease to suddenly stops paying rent or, trashes the place, the landlord could potentially still come after you. So subleasing isn't quite the same as legally breaking the lease free and clear.
Wow, okay. That's a really important distinction.
Yeah.
This is all super helpful. What other sort of general advice or key points come up in these guides for tenants?
A few big ones stand out. First, the absolute importance of a written rental agreement. Get everything in writing. It avoids so many problems down the road.
Definitely.
The sources also really emphasize communication. Talk to your landlord first if issues pop up. Try to work things out directly before escalating.
Good advice. And if talking doesn't work, where can people in California find more help or solid info?
The California Department of Consumer Affairs is a great starting point. Their guide is very thorough. Their website is www.dca.ca.gov. Easy to remember.
Okay, dca.ca.gov.
And they have a phone number too, 800-952-5210. Also, depending on your income, legal aid societies might be able to help. And as we said, for complex stuff, talking to a lawyer is often the best bet.
Right. And on that note, especially for those of you listening in Orange County, Riverside, San Diego, or Los Angeles County here in California, if you're a tenant and you're dealing with something serious like an unlawful detainer notice that's an eviction lawsuit, or maybe you were injured due to unsafe conditions in your apartment, that's premises liability.
Yeah, those habitability issues we discussed become really critical then.
Exactly. Or other real estate disputes.
Yeah.
If you're a tenant facing these kinds of problems, particularly related to the landlord not keeping the property safe and livable, understanding your rights around that implied warranty of habitability is crucial.
Absolutely.
Our firm, Martinez Law Center, is based in Santa Ana, and we specialize specifically in representing tenants in these situations: unlawful detainers, premises liability accidents in apartments, real estate partitions, even auto accidents and workers' comp. We only represent tenants, not landlords, in these housing matters.
So you focus on the tenant side.
Correct. If you're in Orange, Riverside, San Diego, or LA County and dealing with these issues, you can check out our website for more info. It's martinezlawcenter.com.
Martine's lawcenter.com.
That's the one. But please remember, everyone, what we're discussing here today is general information based on these guides. It's not legal advice for your specific case.
Absolutely critical point. Every situation has its own nuances. You really need personalized advice if you're in a tough spot.
Okay, so let's try and wrap this up. The main takeaway seems to be landlords in California need that just cause to break a fixed-term lease.
Right.
But for tenants, the guides we looked at don't really give a clear, simple checklist for legally breaking a fixed-term lease early without potentially owing money.
It's not explicitly laid out that way, no.
However, that implied warranty of habitability is key. If your place is genuinely unsafe or unhealthy, and the landlord won't fix it after proper notice, that does open up potential options or remedies like maybe abandonment.
It creates potential leverage, definitely,
Yeah.
but it requires following specific steps carefully.
So here's maybe a final thought to leave you with. Given how specific the rules are for landlords ending leases, why do these guides seem, well, less direct about the tenant's options for getting out of a fixed term early.
Interesting question.
What other protections or maybe clearer pathways might actually benefit California tenants who find themselves needing to end a lease before it's up? It's definitely something to chew on as you think about your own rights and responsibilities.
Call now 714-442-9741. Thank you.